Gentry Midwifery Rules Advisory Committee meeting is convening at 9:03 a.m. on January 19th, 2023 at the Health Licensing Office in Salem, Oregon by telephone conference call. I will now call roll. Hermine?
Here.
Jean?
Yeah, this is Jeannie Savage.
Oh, Jeannie, sorry.
All good.
Lennon?
Here.
Nora?
Present.
Willa?
Willa is here.
Yes, I see her. Donisha?
Present.
And Silva. Members, when you wish to speak, please state your name for the record. Committee members are asked to not use the chat feature during meetings. Public members wishing to speak must first sign in on the roster sheet available. For public members calling in on the public phone line, please email April Fleming, long email address, and provide your first and last name. Public and interested parties feedback may be heard during the public and interested parties feedback period, if indicated on the agenda. Everyone is asked to use appropriate language, manners, and protocols when conducting committee business. This meeting is now called to order. Okay, hope everyone had a good holiday. We'll just dive right into it. I just got your guys' materials to you yesterday. I apologize if they were late. It's been hectic around here, that's all I'm gonna say. It's new legislative session and it's been a whirlwind. So we called the meeting to order. I don't think we need to introduce anyone. Maybe Jean. I don't think Jean was at the last meeting. Jean, do you want to introduce? I guess we can introduce ourselves so that Jean knows who we are. Soka, you want to go ahead first?
Hi, Jean. We've met a number of times. I'm Silka Akerson. I'm a home birth midwife in Portland and the executive director of the Oregon Midwifery Council.
Lennon.
Hi, I am Lennon Clark. I'm a midwife in Salem, home birth midwife in Salem area.
Jeannie, sorry.
It's all good. Jeannie Savage. I'm the chief medical officer for Trillium, and I'm a family medicine and OB provider at Salud Medical Center in Woodburns. And our deliveries are all out at Silverton. Although I am not doing deliveries as of the last year and a half. So nice to meet all of you. And I just appreciate being here.
Thank you. Willa?
Good morning. Willa Woodard Irvin, midwife, Southern Oregon, and I'm also the owner and director of Rope Birth Center.
Nora?
Good morning. Nora Hawkins. I'm a home birth midwife in Northeastern Oregon, Wallowa, and Union counties.
Hermine?
Oh, hi, Jean. My name is Hermine Hayes Klein. I'm an attorney in Portland, and I'm general counsel for the Oregon Association of Birth Centers.
And Donisha?
Good morning. I'm Donisha from OHA. I work with the Community Partner Outreach Program on the Black and African and Refugee Strategist.
And I am Sammy Patnode, policy analyst for the Board of Direct Entry Midwives and Health Licensing Office. Okay. The agenda's pretty short. We're going to look at, in your materials, I sent the current peer review, what's in the rule now. The two you guys, the 1 and 2 you voted on at the last meeting, and then the new Midwifery Council suggested rule. I put fiscal impact, but we kind of went over that last time. I don't think that changed much. And the racial equity statement, and the board will fill some of that in as well. And then we'll just make a recommendation to which one you guys choose, or if you choose the options again. And then I'll go over the rule schedule. So we will have approved rules soon. So let's dive right in to the text. Everybody got the email, right? Perfect. And then I think it's on page 3. Is where it starts. Yeah. So I will let you guys kind of, so the first one is what's in there now. The second one, I kind of put headers, is the new OMC language. Hopefully I got the strike through and bold right, Zilka. I think I did. And then the third one is option 1 that you guys voted on at the last meeting, which was removing entity, I believe. Yes, removing entity. And the second one was the original peer review rule that you guys voted on in September. So take it away.
I wanted to just start us off in thinking about the current rule because we've been getting a lot of feedback from LDMs about the current rule and just the level of confusion. Like one of the things later on in the packet is OMC recently put out an FAQ about peer review, and a number of the questions are just about the current rule. People have a really hard time understanding what is an entity, what is the requirement, what types of birth they have to review, what does it mean that an entity has this many LDMs, all of that kind of stuff. And so to me, there's some essential functions or peer review that I want to preserve, but the main thing is whatever the peer review rule that comes out of this rulemaking process is, it needs to be simplified and really, really clear so that everyone reading it has the same understanding of what it means, and there's not just a high level of confusion that there currently is. But I don't have any other thoughts about the current rule besides that, especially since this is our second meeting. Do other people have things that they are wanting to say about the current rule?
And we're holding this meeting because OMC provided us additional language. So we wanted the RAC to weigh in, and then we'll give it to the board in February.
Would you want me to just orient people to that?
Yes, please.
Okay. So we've before the previous RAC, but then also after the previous RAC, we've been doing a real information gathering process about how peer review is going, what's meeting people's needs, what's not meeting people's needs. And after the last RAC, that was especially clarifying. It seemed like there were a lot of, I just got a lot of information out of that. And we still feel extremely strongly that home birth and birth center midwives need to be involved at least at some points throughout the year in a peer review program that's part of a quality improvement organization, because the peer review is the core, the heart of how quality improvement and community birth works. It doesn't need to be OMC in any way, but just an organization that's larger than a, 1 or 2 midwife home birth practice, or, we have some birth centers that are just 2 licensed direct entry midwives or 3 licensed direct entry midwives, but where it's part of a larger thing where the structural patterns that impact how birth happens. I think this is something we actually talked about a little bit last time, is so often what comes out of peer review isn't just, what I, Silka Akerson, need to change about what I'm doing, but it's where we identify, oh, there are some problems in the relationship with the ambulance service, or transfer to this hospital needs improved. And there needs to be a system within which that kind of information is coming to light, and there are organizations that can work on that. So we tried to just emphasize some engagement with that piece, and still retain the idea that that sentinel events especially need reviewed. But I think that the way that it's rewritten might be useful for some of the birth centers who are participating in CABC reviews for sentinel events, because I think that the way that that's worded, that the CABC reviews would count as an entity, because that is a midwifery organization, with a peer review, like with a whole structure of how it does peer review in a quality improvement way. And there are definitely 5 LDMs in CABC. And again, just with the previous rule and the current rule, it doesn't mean that 5 LDMs need to be at any particular review. It means that in the organization, there are at least 5 LDMs. So this new language was just an approach to try to respond to some of the things that happened in the last RAC, and also feedback from midwives across the state. We've also done some things that had happened right before that meeting, but that I think are useful for people to know about, like making an online peer review that's available to anyone statewide, and making some other avenues to make sure that people who are further from regional peer reviews can access that. So it's an attempt at simplification, but the core for OMC is that we still strongly believe that every LDM in home birth practice, in birth center practice, needs to be engaging in peer review with a body larger than their practice at some points. That's all.
Does anyone else have any thoughts? Hermine?
It's more a question, possibly for us, the sort of difference between the old rules and the proposed new rules. Can you guys hear me okay? Am I audible? So I think it would be just great to have a little overview, like what are we here for today at its heart? Like what is the fundamental change between the old rule and the new rule? Is that something that somebody, maybe Selka, could explain?
The old rule had more specifications within it, and the language about the entity, from many people said that they didn't understand the language about the entity, and it was confusing to them what qualified as an entity. So it's trying to take out any extra requirements and just focus on the central requirements. LDMs have a requirement to participate in peer review. There's some special requirements around sentinel events, and then defining what an organization is, and trying to make sure that an entity, that a peer review organization or entity is accessible to the multiple organizations that already are in that space, such as OMC, CABC, potentially OABC, if it develops something like that, and also very accessible to future organizations. So that because it was, people just really were having a lot of confusion about what it means, and this just spells it out. It has like a charter and guidelines. It could be 2 pages, but just something that says, this is what we are. We do peer review for quality improvement. Here's how we do it. So it's, just trying to make it really obvious that it's an accessible space, and here's how you access that space.
And the entity
So awesome.
is currently considered 5 midwives. And that's
and I guess the purpose of entity, it seems like at the heart of what we're thinking through here is the fact that home birth midwives work in the community setting. So peer review for medical providers happens within this container of the hospital, where we can really say it was in a hospital room, and it has all these signifiers that let us know this was a protected conversation. So it seems like what we're trying to create here is a rule that's going to serve the purpose of encouraging and facilitating and even requiring the participation in peer review for home birth midwives, but make sure that the rule is written in a way that is going to be protective of those midwives and ensure the confidentiality and the privilege of the peer review sessions. Because obviously the cases where the midwives are facing a sentinel event are also the cases where they are legally vulnerable. So, what I'm looking at when I read this rule is, both the assurance that there's some sort of signifiers in place. And I think that's what we're feeling through with you have a charter, and I'd love to talk about that a little bit more today. But also, what is the understanding of those who participate in the peer review and are receiving the information and offering their feedback regarding, what I'm looking for in this rule is not only that, these folks can't get subpoenaed and called into a trial and questioned about what happened in that conversation, but also an obligation of confidentiality on all participants. I mean, I know HIPAA does some of that for us, but at the same, I would want that to be really clear also within the charters or whatever of whatever organizations are facilitating this. So maybe we could just chat about that a little bit. Obviously, OMC is setting up a structure for facilitating these peer reviews, and you're laying that out in your policies and your facts, and that's awesome. I think OABC is also trying to put one into place for birth center owners or whatever who want to participate in these processes. But maybe we could just sort of talk through, and maybe Silke, again, you could speak to, or anybody else, of course, the ways in which this new rule protects that, and also just what, say we're at a non-OMC peer review, we're just 5 midwives have come together. I mean, I guess this takes us out of the 5 midwives come together because we want something more official around that.
Yeah.
But could we talk a little bit about what it is that we have in place that creates that kind of structure for the peer review, and then what sort of signifiers we would have in place that lets everybody know, okay, we've begun, we're all in somebody's living room, or we're all in, in some space, but this is it. We have now begun the peer review process. Confidentiality is in place and privilege is in place.
Yeah. I'm really glad that you brought this confidentiality piece up. I mean, in some other work that I'm doing with the Oregon Perinatal Collaborative on other things, we've been talking a lot about joint peer review between hospital providers and community midwives when there's a sentinel event or a transfer that involves a lot of conflict or tension. And my understanding is that we're all protected under the same peer review statute. LDMs and CNMs and physicians, we all are just listed under that same thing. And the Oregon peer review statute is pretty general in the way that it's worded. So then each organization that does peer review within that, like either the Oregon Midwifery Council or OHSU or whatever, is responsible for making their tools and their protocols protective in the other ways. The statute protects from discovery through subpoena or things like that, but we're responsible for, having a structure that protects confidentiality from voluntary disclosure. So the way my understanding is that that's on each of our organizations to do that. So like in OMC, when you come to the Portland peer review, we have a signed confidentiality agreement that says, everyone who is participating agrees not to disclose that information in any context. And, that's read at every meeting. And then when we do the sentinel event reviews, we're having, a trained OMC case reviewer involved in each of those reviews. And a huge part of what that training is just about confidentiality and about, especially in the case reviews, we get a copy of records, and that if it's a paper copy, it's given back. If it's a, electronic copy, it's destroyed, just trying to have all these protocols around it. But my understanding is that would be the responsibility of each of the organizations or entities to have their own way of doing that. And I think that, midwives who are experiencing like a license investigation or a lawsuit or a threat of a lawsuit may feel, concern about those sentinel event reviews that way. And I think it really behooves midwives to ask what the confidentiality practices are of the organization that they're doing that sentinel event review with, to ask CABC or to ask OMC or to ask OABC, how is this protected? Have there been any concerns with confidentiality in the past? That kind of thing, because it's a huge and important thing for us to all be protecting. And any breach in confidentiality really compromises our ability to use peer review for quality improvement. The whole point of quality improvement is that it's not about like assigning blame. It's about like looking at a situation and seeing, how could this be different in the future? How can we change systems? How can we, change all of the structures around midwives and the information that midwives have and the education that new midwives have to, support the best care. And if there's any kind of compromise in confidentiality, it really can really compromise quality improvement.
So that's really great, Silka, this idea that, you know, the statute protects sort of like, you know, outward facing confidentiality, if you will, you know, from subpoena and discovery, but that the, you know, this again is another signifier when you're dealing with an organization or an entity that is creating peer review versus when you're with just a group of your friend midwives. And that would be that there is this kind of formality, you know, like what we're really talking about here is creating these sort of formal structures in place for this conversation that protect the conversation as much as possible so that it can be as effective as possible for its purpose. And so, I absolutely agree with your suggestion of those confidentiality agreements being critical to each peer review session, and maybe with some sort of, you know, accountability if that is breached. And then it seems really important that there's just communication with the midwife community. So that could take the form of like a joint statement from OABC and OMC or something like that. That's like, midwives, listen. Because midwives, you know, most midwives, I think you guys would all agree, want to talk when something bad happens or unusual or challenging. They want to talk about it with their peers and process it and understand it. And so this is really about helping them understand there are safe spaces for that and there are unsafe spaces for that. Don't wait for the threat of a lawsuit to ask if it's confidential, because consider it threatened if you have a bad outcome. You know, like consider that threat already in existence and you've got a statute of limitations stretching a few years. So absolutely this conversation has to be protected and confidential. So I guess that part of, you know, any sort of conclusions that come out of this process should be like, you know, some clear memos that maybe this group could put their head together around to make sure that folks know what it means for that to be protected or not protected, because that's just about the most important thing that we're putting in place around this process.
Yeah, I like that idea of a joint memo. And we have a quarterly OMC, OABC, ACNM leadership meeting, and I can put that on the agenda for the next one, because I think there are also nurse midwives who come to peer reviews in both of our organizations. And so I think it would be useful for it to be a three-way thing. And maybe, you know, that way we can kind of like give people some expectations of what a secure confidentiality space could look like, so that people have that information when they're thinking about how and where to review something. And Jeannie, I see that your hand is up.
Yeah, this is Jeannie. I would say that this has been a part of the hospital setting for a long time, and peer review absolutely has to be well defined and confidential, because it is this space where most of us learn and grow from our own or others' mistakes, right? Or issues or things that have happened. And we need to be able to do that in a place where we feel comfortable and accepted and we can be vulnerable. And so to define that space clearly from the get-go is really important. I would obviously in your work, Silka, you're probably already looking at what hospitals have in place. We have peer review at the insurance level, at a CCO level. We have peer review credentials and all of that that's privileged as well. And have a whole process around that, which is similar to a hospital and yet different because it's not that entity. Anyway, I just want to encourage that the clarity of what Hermine is saying, and the outline of it is really important for sure. And I support that, and however that would happen. And I think getting the memo between the three organizations and making sure that everybody can agree on the same kind of setting is perfect. And then just the last little thing I would, we're in two areas. We actually have some connections in Southern Oregon, but no building. But I would definitely volunteer our space as a space for that meeting to happen. So we have a space in Portland and we have a space in Eugene. And if you're I'm just thinking physical space where you would have an area that could be confidential, somewhere where you can shred documents afterwards. And you can have a setting that's, not recorded if you don't want, just some support for that infrastructure. That's just for your information, not necessarily for the meeting, but offering that up.
Thank you. Nora, I see your hand up.
I am just kind of looking at the rule and places we might be able to insert a little language, or I really like OMC's simplified language, and I absolutely agree. It is confusing the way it's written now, and even the first recommendation that last time was kind of the one to remove the word entity. It still has a lot of language that is very confusing in point 2. But specifically that part C of that, which is in every recommendation, there is the definition of what peer review is. And I wonder, could we say something to the effect of, let me find one. The objective of peer review includes, but is not limited to, a confidential review of care provided. Like, can we add the word confidential to that point?
Yeah.
And then, yeah, just to reiterate, I like the simplified language. I think there's parts of each of these recommendations that I really like, and parts that still feel not so good. So when we get to discussing the points of it, we can talk about that. But simplified language, including the word confidential and what peer review is, because then it's law that we have to do it, and to define it makes sense, but at least then it's also clearly a legal thing we're bound to.
Sammy, do you want to be the one to track hands up? I see Heather and then Willa have.
Good morning. My name is Heather
Yes.
Vogelsong. I'm an attorney with the Oregon Department of Justice, and here to provide some background in regards to the statutes that actually weigh in on the peer review and provide that confidential space for you. So there's 687.482, and that's in the DEM statutes. And it says that peer review of a licensed direct entry midwife conducted under 687.480 is subject to the provisions of a different statute, and I'll name that one, ORS 41.675. And then it talks about that charts and records are created during or for the purpose of the practice of direct entry midwifery are not data under ORS 41.675. So basically what this is setting up a structure of confidentiality and setting forth what is protected and what is not, and what is considered confidential and what is not. It talks about in 41.675, it talks about the inadmissibility of certain data. And we can't change those statutes in rule. Those statutes do apply, so you do have that setting, but we can't go forth in our rules and alter or interpret or change that, because it's what applies in statute. So I don't think necessarily that you'll want to go down that road during this RAC for adding in language that pertaining to that, because you already have these statutes that are out there and that provide what is permissible under the law. So, and so those are references that you could look to when you do the group meeting, to do that educational document, to talk to midwives about where protections come from. Those are sources that you can look to. So I want to make sure you have those.
Yeah, I do. Thank you.
Okay.
Hello. I just had two simple thoughts. First of all, I did love the new language about something about, I could go through and find it again, I underlined it, but about every midwife practicing is required to bring 2 cases per year. So somebody, once you're around at peer review long enough, we all know there are certain midwives who will come to every peer review and never review anything and never have anything to say about anything that they're personally doing. And it has always kind of created this strange space when we're all like, well, we would like to know how are you doing? Do you need help with anything? Have you had anything that you need to get, to voice anything we need to, talk about, discuss, figure out, help with. I do think it's helpful because when you don't review something that you've done throughout the year, good, bad, small, large, whatever the problem is, sometimes, we've reviewed strange labs. It's not for any other reason other than, has anybody else seen this? What are we supposed to, have you seen this? This is these are the consults we got on these labs, or whatever the circumstance. And we do all learn from that. I did have a question for Jeannie. you know, I think one of the questions that was asked of me during my time as being a representative for OMC, which I'm not anymore, people asked me all the time, I know this is supposed to be privileged, I know this is supposed to be confidential, but when we leave here, there are certain people in the state that will still talk about it behind the scenes. You know, they always asked me, what are the ramifications for those midwives who are still talking about these things that are supposed to be confidential? I don't actually know the answer to that, but I would like to know if there are ramifications for those of y'all in the hospital, and what that might look like. Thank you.
Did you want me to answer that now? Okay. So yes, there are strict guidelines about confidentiality and what you can and can't say. If you are overheard in a hospital setting and or maybe a private setting and or reported, then the hospital medical executive committee takes it up and investigates on some level. So there's follow-up, basically, and to be completely honest, what we would do when I sat on the medical executive committee is bring our counsel in right away, right? You bring counsel in and you say, this is the he said, she said, right? Because you're getting a report of something that was said. And these are the issues. And sometimes you could see people write up an issue and have that as part, it gets investigated, there's a discussion. And then then it's written up as part of their file in the hospital, and then it goes from there. If it's a one-time occurrence, then it goes from there in terms of what the medical executive group would then decide. But it usually gets brought back to that level, discussed with counsel, and goes kind of from there as a process. I have not seen that routinely happen. I think in a sense of reporting, not routinely happen is people don't discuss outside. I think people probably do, but I have not seen it reported on a regular basis at all. In my experience, just so we know, that's just me.
I'm glad that you brought that up, Willow, because it's something that we've been thinking about a lot lately within OMC. And it's one of the reasons why we started doing Sentinel event reviews kind of in a separate, smaller process to make to make it just a much more solid container around those and have it be a less large group. But also we, for the first time in 44 years of OMC existing, have taken a significant action. And there's 2 LDMs who are not who are not welcome to come to their regional OMC peer review any longer. And because we know that they need to they still might need to access OMC as an entity because of the entity requirement. We've said that they can access that individually or within a smaller review, but there was a huge breach of confidentiality that had major impacts for people. And we went through a whole concern process and trying to attempt at reconciliation process, and finally took that action. So we're trying to take it more, I don't know if it's more seriously, but to actually have processes or actions if something like that happens, because we know that confidentiality of peer review is like the whole center of how it is able to function.
Sammy, could I contribute?
Yes.
Oh, okay, thank you.
I don't always see the little hand, sorry.
Oh yeah, I get it, no problem. I mean, I guess I have two points I'd love to discuss. I want to follow up on what we're talking about here, but also maybe tie it also with the question of how does the midwife keep a record that she's done 2 peer reviews, and is it an idea that we're asking the organizations hosting them to keep a record of a logbook, you know what I mean? That's basically dates of peer reviews, who was presenting and who was attending, so that can be verified. It just seems like, so I guess I'll hit this issue first because it's the smaller one. It just seems like there has to be some mechanism for accountability. I don't know, Silka, if this is all, I don't, maybe you can advise. Is there an audit of this issue? When does it come up? when and how is a midwife asked whether she's done this? Is there an annual moment where she relicenses, where she has to certify that she's done to? Does she have to prove it in any way?
Yeah.
Like, I guess that's question number one. Maybe, and then I'll hold off on the
At relicensing, she has to attest to that she's
Okay.
done it. And then if there was an audit or an investigation, then she would have to provide proof. And it works. We've actually been talking about making this more. This is something that I don't think should be addressed in rule, but each organization needs to have figured out. And in OMC, normally how it works is when you go to the regional peer review, for example, you get a certificate of attendance that then is your records and you're able to account for. But we've been looking at doing a model more like Moz. Like, we are really aware that people might need sometimes proof of it, so we're keeping some record, but we're trying to look at a more formalized way of doing it. Moz has more of a logbook, like what you're talking about. It's online, so every time there's one scheduled, since there's a ton of different people scheduling them, there's a record of, this date and these people.
Even a Google sheet could work for that.
Yeah.
Yeah. Okay. So that's and kind of attendance also great. But yeah, I think just also for the organization's purposes, and there might be some sort of annual or regular moment where we come together and sort of track who's going to who and try to figure out, like how is the state distributing among the different organizations available. But I guess back to the confidentiality issue, it seems like the only mechanism, because of course, home birth midwives are generally self-employed, right? So unlike the hospital where they might have an employment consequence, that's not really going to be in effect. And so, exclusion from peer review is kind of the only lever we've got to pull with regard to breaches of confidentiality, and really it could be a one strike.
Yeah.
One strike.
This was a one strike. It just took a long time to get there.
No, I get it. Yeah. And I'm not at all on the process that you guys have just gone through. And I think there've been at least one violation of, there've been numerous violations of confidentiality in midwife peer review. And some tied to this question that I think also needs to be clarified for midwives of what is the interface between your obligation to participate in peer review and your sense of whether you're a mandatory reporter for anything, you know what I mean? Because I think some midwives, like maybe in that situation or whatever, have this idea that if they hear about what they perceive to be negligence, they have an obligation to report it to the board. And so I think clarity around how that fits into the peer review process is going to be really important. And then one more issue I want to flag before I pass the mic is just in terms of what you raised before, Silka, in terms of they have to fulfill their requirement, but an individual organization might say, sorry, you breached our policy, so you're not welcome at our peer review anymore.
Yeah.
I think it really sort of gets to, well, what are their other options at that point? And that's why it's important to track. So if there's OMC and OABC are two state orgs that will be doing this, right? And I think I heard you mention that CABC is also a resource that Oregon midwives can participate in. And I don't know, does that work with other Oregon midwives or they bring in national midwives at CABC? You know what I mean? What does that look like? And could that be a last stop for the people that blow it here in Oregon?
My understanding is the CABC accredited birth centers already have to review their sentinel events with CABC. And I tried to rewrite the entity piece so that CABC would count as an entity because it is an organization that already has those structures and it does peer review for quality improvement and it does have more than 5 LDM members. So it's a birth center specific thing. And I was just trying to support a really valid avenue of peer review that's already happening and making sure that those bodies that exist can function to meet licensure requirements. I think. Go ahead. Sorry.
Do you happen to know if CABC, if those LDMs that are part of their peer review are Oregon LDMs or are they licensed in other states?
Well, there are more than 5 LDMs in CABC as an organization.
Oregon LDMs?
Yeah. In most other states, they're just LMs.
Okay. Thank
you.
So
LDM is usually just Oregon specific, but
That's great.
But for the individual review, say, I'm midwife working at a birth center and I have a sentinel event, for the CABC review to count for the LDM licensure requirement, it would just mean that there would need to be one other, in this new proposal, there would need to be one other Oregon LDM involved.
Okay. And I guess we could, like you were talking about, hold space for the fact that folks might violate confidentiality as a listener and therefore should be excluded as a listener, until and unless they prove that they've solved their problem. But that doesn't mean that they can't come back as a presenter, because they're not endangering anybody else if they're presenting their own case.
Yeah, and that's
so maybe that has to be part of the policy.
We tried to present like at least 3 other options for the way that they can meet their peer review requirement. They just can't listen to the cases in this community where they caused harm.
Okay, thanks.
I also just wanted to say very quickly, CABC, well, my birth center is not CABC certified. We're a very small birth center, and I think there's us and maybe one other one in state that's not. But there's also MANA, NACPM, evidence-based birth. There's other entities besides CABC that some of us do peer review with, and it might be like 2 of us from our birth center and 1 from Roseburg and 1 from Eugene, and usually we kind of all call each other and we're like, hey, we're on with MANA right now doing it, which after this week, but anyway, we're on MANA doing a peer review right now. Who's got anything to review? Can you come into the case? Do you need help? And we try to help each other as well. So there are other entities, but having said that, it's never quite as, I don't want to use the word intimate, but quite as close to home and meaningful as it is sometimes when it's someone closer, someone that already knows you, someone that's practicing in the same community or close by instead of somebody in Jersey or whatever else. I mean, I have lived on the other coast too, so get it. We all practice similarly, but it's just very different for regional wise.
Someone who understands your transfer relationships where you are, someone who, understands what the ambulance transfer is like there, what your rules are. Yeah. I think that these topics are really interesting, and it's making me think that we probably need to have a separate meeting that's just about like all of our Oregon organizations kind of coming together and doing a kind of an assessment of where we're at with peer review and having, some, a memo of some joint understanding. And I think some of this doesn't relate very specifically to the rule, because a lot of that is stuff that we need to do as the organizations. So I'm curious, how do we use this time that we have together to focus on what's appropriate to go into the rule, and how do we make sure that we're following up outside of this meeting in our organizations, mutually with our organizations, to talk about the stuff that's more organization-based, practice-based, not the rule. Nora, I'm curious, you had mentioned earlier that with each of the suggestions, that there's some things that seem really positive to you and some things that still don't seem functional. I wonder if you could talk about in the new language that OMC suggested, what your areas of question or concern are.
Yeah. So the one that Sammy put together, the numbers are different than the one that you attached. So going on the one that she put together, I think 1 through 4, those points all seem great. And I really like the simplified language. Point 5, I'm still struggling with the entity piece. And so I like what we did with our other recommendation last time of removing that wording. I think the vast majority of peer reviewers are still going to be in that. I just feel that for the few people that might alienate, it's not worth having it in there, that language, even though I do understand a lot of why it's great. And I think the vast majority of it would be. I just feel like there's already some oversight as far as we have OARs, but then we have HERC that's limiting it differently. And then if we have organizations that limit things differently, it feels like we're kind of being, I don't know, the right words, but it feels kind of constrictive. So that entity piece I still struggle with, even though all of the peer reviews I've attended would fall under that. So I understand that it's probably the likelihood. So that piece, the entity, and I realize it's called organization in the new language, that I still struggle with that. The other thing is, like Willa, I think it's good to have, I was kind of had both hands with the needing to be required to present. That part of me thought, if we're only, attending to and we have to present to, are these peer reviews going to turn into 8-hour-long things so that we can all get our mandatory presentations in at the same time that we're doing our mandatory listenings and that are attendings? And that doesn't seem great, but I do agree that it's nice to have everyone participate. And so I do like that. And I wondered if it, could be one, or could it be like our continuing ed is not a year, but it's every 2 years. Like, can we be required to present once every 2 years? So like when we do our continuing ed, we also we testify that we have presented at one in the last 2 years. Was kind of just an alternative to that idea, but I'm rambling. I like simplified language. I think points 1 through 4 are good. Point 5, I struggled with the being required to present, but I don't dislike the idea. I struggle with the idea of the mandatory organization word, but I don't totally dislike the idea.
Yeah, I get that. There's definitely some midwives in the state who, really bristle at any idea of like presenting to anything they feel like is an authority or an oversight. And I think the reason why it's so important to me is because of the number of times I've witnessed the pattern of an LDM who is not engaging in peer review and continuing education with the community, starting to behave in a more and more extreme manner and endangering the families that we serve. And I kind of think that real peer review, where you have to show yourself to your peers and think about yourself and reflect and grow, is the price of admission to this like sacred work of having people's literal lives and health and well-being in our hands. Like, to me, the fact that it's uncomfortable or that it's challenging to show up is not an adequate reason to not engage. And I totally get that someone might not want a peer review with OMC or with OABC or with whatever organization. And in other states that have a requirement like this, like in Washington, they just created another organization. Like, it's not okay with me for someone to practice as a midwife and shield themselves from being seen by some peer in this work that we do, because we can get really out of whack. We can get to a place where we are doing things that are really compromising informed choice or the rights of our clients. And if we're just functioning in isolation and no one ever sees us, the consequences can be high.
I guess to me, I'm not seeing that participating in peer review, whether it's with an entity or mandatory just twice a year, they're not mutually exclusive to me. I feel like if you are participating twice a year under these provisions we have where the people are outside of your practice and there's at least 3 or 5, whatever rule recommendation we're looking at, to me, those things do make it so that you are attending peer review with people outside of your practice. It's just does it have to be an official organization that has these things? And again, the ones I've attended one that was not. So the vast majority of mine are. And then I think if somebody listening to the string of acronyms, which I must admit I'm not familiar with what all of them mean, if you're a home birth midwife and you're not a birth center midwife, are you welcome at those peer reviews? So if someone were to breach the rules of OMC and not be asked back, then do they not have other options? And I don't know the answers to these things. They're just things that come up as I'm listening to this as being potentially problematic. But I do think there's ways in the language to clarify, you know, is it 3? Is it 5? You know, we had said people out of peer review. How many of them need to be outside of your practice? It had been 2, and some of the suggestions I see that's been moved to 1 outside your practice. I kind of liked it being more, but anyway, I think there's other ways without mandating that it's an entity that's separate to make sure that people are attending peer review with a diverse group of other practitioners not in their practice.
It's
But
just,
that's it. I'm just trying to speak to that alienating some piece.
I'm just aware of a number of peer review meetings that are 3 friends who practice in the same manner, who confirm, say, you did everything you could, that was great, I wouldn't do anything different.
Gotcha.
Great job. Hermine, sorry, I forgot your hand was up. You're muted. You're muted.
All right, thank you. I mean, I think it's important to say, and especially for those on this call who are not midwives, LDMs, who are not familiar with the existence of this board, whose meeting we're on right now and the work it does, a lot of people in this state have the idea that lay midwives are running wild and that there's no oversight and accountability for them. And this conversation about how we need peer review to check all of these running wild midwives could feed that misunderstanding, because, like, I mean, as recently as this year, when I'm advocating, the last year while I've been advocating for, you know, OHA coverage for out-of-hospital birth, I'll be hearing from the nurses at OHA whose job it has been for over 5 years to review each and every home birth case for coverage, that it is their understanding that unlike nurses, unlike doctors, lay midwives have no rules for oversight. And so the danger is that they're just out there with no standards. And so that's why we need people like Gloria Stubbs, who has no knowledge or experience or anything regarding out-of-hospital birth, to review each and every file to make sure that dangerous, foolish midwife isn't doing something dangerous and stupid. And that is false.
Yeah, that is false.
Because we have a board of direct entry. Let me just finish. We have a board midwifery that enforces. Can you guys still hear me, or am I frozen? We have a board of direct entry midwifery that enforces extremely detailed Oregon administrative rules for the practice of out-of-hospital birth. And there are mechanisms for accountability that are fully in effect. Yes, they take a ridiculously long time with this board. Yes, it takes years for them to follow up on investigations a lot of the time. Those are processes that can be addressed, but the processes exist. Mechanisms for accountability absolutely exist. In addition, we're talking about licensed midwives here, you know what I mean? So we're talking about midwives who have to do certain things in order to be able to practice in this state. That includes, for example, continuing education that they have to take every year. So there is no midwife hiding out at a cave, not learning anything, not advancing, never evolving, and sliding deeper and deeper into madness and babies dying along the path. That is not a thing. And we can all know that on its face because we understand the rules of licensure in this state. So while peer review absolutely has value and is a very important piece, right, of that maintaining excellence as midwives and being in community. Now, after all, one of the most important functions for peer review is that it sets community standard. And community standard is the standard underneath the OARs that determines whether a midwife is acting competently and non-negligently. And that is something you could say even that is like organically evolving through dialogue of the community. You know what I mean? It's not a static thing. And it's something that, as has been raised in this session, is responsive to, well, what are we dealing with here with our local hospital systems? What are we dealing here with our emergent transfer systems? And we are adjusting our practice collectively to try to provide the best care possible in community according to our community standard. So that has great value. It's critical. It's one of the reasons that we're supporting regs that require peer review. But let's not make any mistakes about whether peer review is the only process that is holding midwives accountable in this state, or make the mistake of believing that our existing processes are such that they would allow a licensed midwife to be living in a cave, going crazier and crazier with her practice and harming and killing mothers and babies. It's not a thing. And I think it's important to say, because these kinds of stereotypes make it very difficult for midwives to practice. And they also make it very difficult for the families who access midwife services to get coverage. Because again, we've got foolish rumors floating around right here in the state of Oregon within agencies that absolutely should know better, because the law is clear and they can see on the face that midwives are held accountable in all kinds of ways.
Yeah, I'm really glad that you're bringing up stereotypes, Hermine, because we deal with a lot of them. And I think it's important to just note that every profession has outliers. It's not something unique to midwives or home birth midwives or birth center midwives. Physicians have outliers, nurses have outliers, chiropractors have outliers, naturopathic physicians have outliers, physical therapists have outliers. And I don't in any way intend to say that midwives are wild and more than anyone else, but every profession has people who are very much in the center, people who are pushing the edges in ways that are productive for the profession, and people who are pushing the edges in ways that are compromising the profession. And that's no different for midwifery. And I feel like the difference between the way that peer review functions to hold the profession from the way that the rules and the license investigations function to hold the profession is that the peer review can be more preventative and proactive, whereas much of the license investigation is after the fact. And so I think that they work really well in conjunction. I in no way mean to say that like midwives are, I'm not trying to make any broad strokes, but like every profession, we do have some outliers who we're trying to hold in the community in a way that supports the best care for the families that they serve. And I just have been doing this for long enough that I think that a license requirement for peer review with an organization or an entity is essential for a very small number of midwives who would otherwise avoid having a more formal peer review that's held in community with an emphasis on quality improvement.
I mean, I think ultimately none of us are, like, we're all kind of in agreement. I mean, and I haven't heard anybody disagree that peer review should be mandatory for licensed midwives, you know? So, I mean, I guess, can I revisit an issue that I raised a little earlier regarding the interface, or how we can help midwives understand the interface between their obligation to confidentiality and protection in a peer review conversation and their perception of themselves as mandatory reporters for neglect. And maybe something this is you could speak to, Jeannie, or Heather Vogelsong also, you know, with your understanding of the interface of all the statutes and rules on this point. But Jeannie, you from a practice perspective, I mean, all healthcare providers have an obligation to report, you know, neglect of a child, for example. And so, for example, if say they're in a peer review where there's an allegation or maybe an agreement among those who were present that action was not taken swiftly enough, you know what I mean, in order to intervene on a child's behalf. So that, you know, that the group might agree that kind of looks like neglect of this child, and we're here to tell you you've deviated from standard of care. We don't want those folks filing complaints on each other. Like, that seems it's inappropriate in this. It seems inappropriate to me that peer review would lead to the filing of a complaint, and I could see that it would make people hesitate to participate. So, Jeannie, can you speak at all to how you guys deal with that in the hospital setting? Is this an explicit exception to the mandatory reporting law? And Heather, can maybe you have something to say on the topic?
I'll just jump in that it's outside of the scope of this rulemaking. And so I think that's something that could really be addressed elsewhere, but that is outside of the rulemaking.
What does that mean when you say it's outside? What does that mean, Heather? What does that mean to say it's outside the scope? Because it's clearly an issue that has to be addressed and acknowledged in order to finalize these rules. So, I mean, what is your understanding of the intersection of the obligation of mandatory reporting and the protection of peer review in general?
Right, so I'd just refocus the RAC back on the the rules that the board has tasked the RAC to be looking at and to be providing feedback on, and the scope of what they're asking you to do with their peer review rules.
That's what we're doing. I'm hearing you say that you don't want to answer that question regarding how the obligation of mandatory reporting affects peer review rules.
Yeah, Hermine, I'm not going to provide an analysis or direction on that, as it's not relevant to the rulemaking.
Well, it's definitely relevant, but I understand if you don't want to answer. We definitely have to have an answer to that question in order to guide Oregon's midwives and in order to know that we have achieved our collective goal for this conversation, which is ensuring both that Oregon midwives participate in peer review and that those peer review conversations leave those midwives safe at the end of it, that they are not endangered by their participation in these conversations. So we have to resolve that. Whether they're endangered by participation in these conversations is certainly relevant to this conversation. And we have to figure out whether the rules that we write in intersection with existing statutes and rules achieve that critical goal.
So the board has jurisdiction over certain things and not over others. And so the rules that are put before this committee are what the board has jurisdiction over, and they've provided some language that they would like your feedback on.
I guess my follow-up question would be, my follow-up question would be, I think we're all licensed with our board. So I'm licensed with the Oregon Medical Board. And if there is a report to the board, then the board does its own independent investigation. So a report is not an assumption of neglect or an assumption. When any report goes to the board, it's so that the board then investigates and has the advocacy and the best interests of the provider usually at heart to do. So I think it just depends on your belief, and it looks like you don't have the same belief in your board as I think that some other boards, like the board is supposed to do. The belief is that the board does its own independent evaluation of the group that was, or of the person who may have been. If I get reported, I hope that the OMB is doing a report that's independent, and I'm assured that's the case. So that discussion, however, maybe I don't know what Heather said in terms of whether that's part of the scope, but that discussion may be leading down an area that may not. I don't know, Silka. I'm not sure exactly about that rule, but to me, that a report then leads to an independent evaluation by the board that licenses you and me, I should say.
Right, but it's true that the board has to, so someone files a complaint to the board, say a midwife goes to peer review, tells her story to 5 midwives. One of those midwives says, you know what, that sounds like negligence, files a complaint with the board. Now that the board, indeed, the DEM board considers it its obligation to look into all complaints generally and make a conclusion. And, unless the board, so that this is why the board could actually provide guidance and clarity within this meeting context, which is, does the board have a policy in place such that if a midwife is filing a complaint that comes out of peer review, the board's not going to turn that into an investigation because it's coming from an inappropriate context? That would be a policy that would then provide certainty and guidance with regard to this. But if they're going to follow up on investigations that come out of complaints from peer review, that process is costly. Even if it ends up in a finding that there was no negligence, it's costly, it's stressful.
I'll just redirect you to the statutes that I referenced earlier. So that provides the protections and the policies as to what the board does and does not look into. Again, is not part of this rulemaking. Stuff that comes up in peer review is dealt with under the statutes, and that guides what the board can and cannot look into. And peer review information that comes out of peer review cannot, I can refer you back to the words of the statute. It talks about how records and data is confidential. So that would be excluded from the investigation. So again, that's outside of the rules and what's being addressed here today.
I think that
there's statutes on that.
I think maybe this is something we should talk about in our joint
Yeah.
meeting with.
But I think it's important to clarify for the midwives here what is being said and what that means from the perspective of the statute. It means that what the board would therefore, exclude as privileged is the conversation that happened in peer review and the evidence around that conversation itself. It doesn't mean that they're not going to go into the files and the records and look up what happened in the case. You know what I mean? So say Nora had a birth, a baby died, and she brings her records to peer review. They have a conversation about it. Notes are taken in the meeting about what everybody thought, right? And then one of those midwives files a complaint with the board. And the board decides to do an investigation of that. What's excluded is the notes, et cetera, from the peer review session. And potentially the participants in the peer review could not, participate in the investigation. The underlying case itself is still fully open for investigation. You know what I mean? Your records, what you did, how was the transfer? So it's not like the case itself is protected from investigation or a lawsuit or whatever else. And that's perfectly legit because we don't want people's participation in peer review to mean that the case itself is suddenly protected from scrutiny at all, right? You can still be scrutinized for negligence in a case you had peer reviewed. What is protected are the records of what happened in the peer review session, not your underlying records of what happened at the birth.
Yeah, and I think this is something that we need to address in the kind of charters and norms of the organizations that do peer review.
Potentially.
Lennon, I'm curious to hear what you think of the newer language.
Yeah, so this is Lennon Clark. Sorry, I think I'm supposed to say my name. I'm kind of quiet. I'm just getting home from a 2-day birth. So that's why my brain's a little slower this morning. But I really like the language that the OMC proposed. So that was, I read it and I thought, oh, I really like how simple it is and straightforward it is. I was one of those people that was really confused about the word entity. So I think it's good to get rid of that and kind of just keep it really straightforward and simple. I'm somebody who likes going to peer review, but I do know there's midwives that don't for various reasons. But I think that having the requirement to have to share, even if you didn't have anything that you think is out of the ordinary, I don't know. Like you were saying, I think it was Silka who said, like, there's information you learn from just hearing, even just like, oh, this kind of interesting thing happened at this birth. Like there was no problems, everything's fine, but I'd never seen this before, and then somebody else will be like, oh, I didn't know that was possible,
Yeah.
So I think it's important to just share, even if it's a quick 5-minute, like if you really have nothing really to go over, you're just kind of going over because I'm supposed to, I have to now go over these 2 cases a year. So then that kind of forces midwives to share. So
I guess my question for us now is kind of what else, is there anything else that we feel like we need to discuss before we just do the thing that we'll do, which is kind of like, I don't know if we call it polling or voting on the different options that we have to make our recommendation to the board. What is still undone before we want to do that?
Well, I think there's probably going to be a lot that's still undone with this group. It sounds to me like we need a much deeper discussion outside of what we're doing today. I would say I think it's going to be hard to decide which way to poll or vote until we can all feel, because I think at the core of what we're all trying to do here today is that we all believe that peer review is important. We also all want to be extremely protected against those that maybe don't want to protect us. I can only speak to the experience I have, and I agree. I love going to peer review. I love holding peer review. I love discussing peer review. I think that one thing, I think we could throw everything else out in all of these proposals, honestly, except for the one thing that reminds us exactly what peer review is about. I think that midwives in Oregon peer review all the time. I think at the core, they're not peer reviewing what an actual peer review is, because a lot of the peer review that goes on in this state is storytelling. And sometimes that's great. but defining that in this, you know, that you're actually supposed to find maybe some educational opportunities or something else, reminding people what that's for. But I think at the core, we're here because truthfully, a huge majority of midwives in this state do not feel safe. Number one, doing peer review. They don't feel protected with who you're doing peer review with. Number two, majority of the midwives in this state don't actually trust 100% that the board is looking out for them to protect them. And so I think we need to make sure that we get that protection written into these rules so that every midwife, and I'm not saying this is my experience, I'm just saying this from being a representative of my region for 3 years or 3.5 years or whatever it was, and the feedback I've received from that and from training students that are now working in other areas of the state that still have the same problems that we had here in Southern Oregon with peer review. I mean, I'm just saying those are the two things to me, like making sure everyone understands what peer review is about, number one, and number two, that we are completely protected while we're trying to share and learn. Because Hermine said it right. I mean, like, if we were OBs, I mean, we had a peer review with, just an example, a peer review with maternal fetal medicine and some of the neonatologists a few months back. And, you know, after the peer review, their words were, you know, the midwives at this birth center, if something hadn't happened in their lives, they would have been fantastic OBs. Y'all went a different route, but you're still, like, you're caring for people as deep-heartedly and even more so than the typical OB at the hospital that they see all the time. You know, we feel protected in that. And it's not that because there weren't 15 other midwives there, it's because we know we're with people who absolutely respect and you trust, that aren't going to take the conversations out. And so I think regardless of whatever else this board does, we need to make sure that we as midwives are protected, not only from each other to make sure that we can trust each other, but number two, from our board, who isn't always looking out for our best interests in some cases. Or, I mean, we pay an astronomical amount to the board to do investigations and other things, sometimes because of, you're right, peer review is supposed to be privileged, but often a peer review complaint is then going to lead to an investigation complaint on a birth, which probably should have happened anyways. You're right. But when it comes from peer review, it feels different.
I mean, I think something that is really important to talk about is my understanding of peer review across the board is that peer review should not be the origin of complaints. And that's the way we structure our agreements. You cannot have candid review of a case if someone feels like they're under threat of complaint. And many people know about a case when there's a sentinel event or a concern. The people in peer review aren't the only people who know about it. If a complaint needs to be filed, it will be filed. Those intents are at cross purposes. You cannot have effective quality improvement or effective peer review if a person being reviewed feels like reviewing it will put them under threat of complaint. And I don't think that that's incompatible with our statutes in any way. In fact, I think it's supported by our statutes, but I don't think that the statute, the LDM statute that we're under, or this rulemaking process support us getting into that any further in this rulemaking. I think that's something that our organizations have to be responsible for. And, you know, that's like a lifelong process of figuring out how we can be responsible for that. And I think a lot of what that means is for sensitive cases, they need to be smaller reviews where the, you know, selection of who's doing the review and the container the review is happening in is really particular. I don't think we're going to fix that in the LDM rule. And the other thing that I wanted to say is that, you know, the purpose of any licensing board is not to protect the profession, it's to protect the public that's being served by the licensed type. And so it, while I also hold things that could be improved about the way that the board works and the way that investigations function and the culture of the board, feeling protected by our board is not compatible with their like statutory or ethical mandate, which is to protect the people that we serve.
I do agree with that 100. I realize that about our board 100%. I guess the complaint from most midwives in the state that have spoken to me at least, would be the fact that we pay an astronomical amount for licensing every single year compared to any other state, pretty much specifically in order to be investigated. So I'm like, I mean, even OBs don't pay as much as we do. There's like, I've never talked to another licensed professional in this state that pays as much as we do every single year. And so that was my point. Like, we're actually paying to be constantly investigated. And that is, and I did not create that sentence. I mean, when I came to this state 8+ years ago, that was one of my first introductions into licensing, that I was told from my first employer here, was that, be prepared, that, our license is high in this state. I knew that moving here, mostly because we have so many ding dang investigations. And I have known people that, were under investigation years back, solely because of a complaint from a peer review. I mean, we've all been down that road, and that's all I was trying to say, is that we do an astronomical amount of money out of our pocket for CEUs and everything else that we do, and then for licensing, it's just not clear cut written in our rules how we're protected, and I just know that's always the conversation.
Yeah. Lennon, did you had your hand up?
I didn't want to say very much, just that I think that it's all perspective, because I know when I first licensed, I think it was $2,000 a year. So I feel like it's not so bad now. I think I paid $600 when I renewed. But I think Alaska is like $2,500 a year is what I've heard. But I mean, that's not insignificant. It's still a lot of money. So, and you're right, Willa, like all of the other things we have to pay for, all the CEUs, and like it all adds up. So it's a lot.
Yeah, one thing I want to make sure that we understand is that there are very, very, very few license complaints that come from other midwives. The vast majority of license complaints come from receiving providers and nurses, and then a smaller number from family members and sometimes clients themselves. The board actually puts out reports about the proportions of that kind of thing sometimes. And I also track it from things that I know about, but it's very rare that another midwife is the source of an investigation. And the license cost is a problem in every state that I'm aware of that has an independent licensing board, because we're a small profession, so it's a small number of licensees covering the cost. And then because we're a marginalized profession, because people are unfamiliar with or uncomfortable with home birth centers, midwives, there's a much higher frequency of filing complaints because of just the underlying discomfort or bias about the profession. But I don't think we can fix any of that in this rules advisory committee. Like, not to say that it's not important at all, but I think in this rules advisory committee, statutorily and in rules, we're restricted to just, all we're doing is making a recommendation to the licensing board about the wording of the peer review requirements. And we've heard really clearly that we can't make wording about the confidentiality, since that is related to the peer review statutes that Heather Vogelsong was talking about. So I guess I'm curious, is there anything in the worded content of these three proposals that we still need to talk about before, I don't know, Sammy, if you called it polling or voting or whatever on them?
You guys can vote, poll, it doesn't really matter. We just, at the end, I'll make a recommendation based on what your decisions are. If you want to poll because you have more than one recommendation, probably a poll. If you just have, you all agree to one, then we'll do a vote.
Okay.
How's that?
Sounds good. Nora, it looks like your hand's up.
Yeah, just to bring it around, as far as the previous agreed upon RAC points, like the recommendation 1 and 2, I like recommendation number 1, except for all of the jargon and language. But there are things about it that I like a lot. I don't really like the recommendation 2. because of the entity language. I do prefer OMC's recommendation because it's much more simplified. It removes the word entity, puts in organization. And I guess my comfort level of moving forward to that one would be, could we change they must present 2 per year to they must present 1 per CEU cycle. So it's like every 2 years you have to do 1 rather than 2 every year.
What about one a year, Nora?
I still struggle with, I feel like we are limiting ourselves more than other professions are, and there's a long history to get us the privileges we have now. So to self-police ourselves when other organizations are not even required to do what we're already doing doesn't feel, to me, in ethics with how midwifery moves forward. So I personally am not comfortable with that. And I feel like, yeah, I think 1 every 2 years is a great addition, but we've already stepped it up so much. We've already gone from 1 a year to 2 a year. And now we're saying there has to be an organization. And now we're saying we have to present 2. It just feels like we're limiting what we
We're
can
already at 2 a year. We just didn't say anything about what participation meant. So it's not changing the frequency. It's changing that participation actually means that you, and I just want to remind us that other professions do have lots of requirements about this. They come from their employers because they're in large employee, hospital organizations, healthcare systems. We are unique in that we are such independent providers that our requirements come from a different location.
Yeah. No, I meant going from 1 to 2 in 2019 or whenever we added that.
Yeah. Yeah. It sounds like maybe we're just gonna have different recommendations about that. I could go down to 1 a year, but I think that the rhythm of participation is really important, and 1 a year is so little. It's so little. I think that what my best guess from where we're at is that we're still going to be where we're going to be presenting a really mixed recommendation to the board, and that's fine. That's actually great information for the board to have, that we are in different places about this and we have different assessments of this. So my thought would be that we should just pull on the options, and the board can, hear this whole discussion and see the range of where we pull at, and then they'll have their discussion from there. I don't think that we're going to come to full consensus, and I think that that's fine.
Is it worth it to, this is Nora, is it worth it to anyone to change the wording on recommendation 1 a bit to reflect the simplified language of OMCs, to kind of merge those 2 in a way?
You mean the original recommendation 1 from last meeting?
Correct.
Yeah.
Yeah. So that original recommendation 1, point 2 and 3 have a lot of jargon that I think is pretty confusing, and that is where I really like a lot of OMC's simplified language. So I think what I would love to recommend would be a mix of recommendation 1 and OMC's recommendation.
I do agree, Nora, that the easier to read, the better it will be across the board. And yes, I do like the wording of I do think it's much simpler and easier to read and understand across the board, the newer OMC peer review recommendation. But yeah, there are some things in there that I think we maybe combining the 2, taking bits and pieces from each of them, because neither of them are 100% spot on. And you're right, Silk. I mean, I think it's great that we're having all this debate, that not all of us have the exact same opinion. And I think that's how we ultimately end up with what should be the best for everyone, hopefully.
I'm happy to change in the first proposal. I don't have an opinion about the option 1, Nora, because I'm opposed to it. But in terms of the OMC option, I'm happy to change it to 1 a year for that one, for when we do the polling. Presenting 1 case a year.
Okay, that's what I was going to clarify. You're saying like just moving it down from required to present 2 cases a year to present just 1. Okay, thank you.
This is Nora, and I think as we've discussed the entity moving language to organization, I still am uncomfortable with the ramifications it might have for midwifery as a whole. But I think that in general, it is the vast majority of peer reviews that are out there. So it's probably fine. And while it doesn't sit really well with me, I'm willing to move forward with that. And while even 1 a year also does not sit well with me, if that's the language of it, my hope is that the board, when they review this, hears my heartfelt recommendation that it be once every other year, like our continuing education, when we test or certify that we, or attest is probably the better word, that we have done our continuing education, that we have also attested that we have presented at 1 peer review. And I worry about the time peer review will take. And it's just alienating, I think, to mandate too much. But if we can move it to once a year, that's better than 2. And I am, through this conversation, coming around to accepting the organization language.
So Nora, do you want to change the wording of option 1 before we poll?
I guess I don't know if everyone else wants to change it. What I would recommend would be pretty much removing one minute, sorry. An option recommendation 1 from our previous meeting, I think point 2 is much too wordy. And we could remove almost all of it, with the exception of the piece that it remains the same through all of them of what the definition of peer review is. So I think removing all of that wording. Let me go back to it. So just keeping 2C, removing 2A, 2B, and 2D. And then in point 3, maybe removing point C, because that is pretty confusing. And I think, yeah, A and B are okay.
Sammy, are you getting that?
Yeah, I think so, for the most part.
Do you want to repeat it once?
Yes, that'd be
Nora.
great.
Sure. So in the recommendation 1 of the previous meeting, under point 2, removing subpoint A, removing subpoint B, removing subpoint D, and then under point 3, removing point C,
Got
and
it.
that's it.
Okay.
Oh, okay.
Jeannie, you had your hand up.
I'm just curious, Hilka, from your standpoint, when you brought this part about having to present the peer at, it's present and or attend, and I think there's an attendance as well as a present, and I'm just curious if that's standard of care for other professions or other states, and if that's how you had brought that to
For
the
other states,
recommendation.
Yeah, there's other states that have that requirement in recognition. It's actually also part of building trust. When we're talking about all this confidentiality stuff, it's really challenging to feel like the trust is there if the vulnerability isn't mutual. if some people are always showing their care and getting feedback, and some people are always, not showing their care. It makes it mutual. Yeah. But that's the case in in Washington, and it's the case in some other places. I don't know about other professions. Community midwifery is just so different in that we are like, my practice is literally me and one other person. And so our relationship with the larger bodies is really different because of that. So my proposal is just that we poll and present the board with our complex reality and go from there. So I think because this is complex, instead of like yes, no votes, it would probably be useful to do polling, like kind of like we do on the birth center rack, where, if we fully support a proposal, it would be 5, and like 3 would be neither support nor, oppose. And then I can't remember, does it go down to just 1 or 0, Hermine? I just completely blanked.
Does what go down to 1 or 0?
When we do polling in the birth center rack?
Does what go down to 1 or 0? Oh, I think it goes down to 1. It's
1.
5 to 1.
Yeah. Okay,
Yeah.
so then 1 would be like, I hate this. So.
And 5, like, knock it out of the park.
5 is like, great, okay.
The thing with the birthing centers, they actually have a polling system.
Yeah.
So
Luckily,
it's going to be difficult for me to do that without a system.
I'll tally it and I'll tell it to you.
Okay.
Okay. Who is actually a voting member of the RAC? Is it everyone whose picture is up?
Everybody, Donisha is, and all of you, and Donisha.
And Jeannie?
Yeah, of course.
Okay, so that's 1, 2, 3, 4, 5, 6, 7. I'm just trying to make sure that I can see the total number.
Yep, 7.
Okay, 7 total. Okay, so we're gonna go ahead, Jeannie.
Apologies. I felt my presence was more as a member of the public, more listening. I didn't know that I was voting on or allowed to vote, to be honest.
Absolutely, you're allowed.
Oh,
You're part of a governing body. The RAC is a governing body.
okay.
Okay.
Great.
So we're doing polling on, let's do the new OMC option, the revised option 1 that Nora just outlined twice, and then the old option 2. And for those of you who are on camera, just hold up your hand and keep it held up until I'm done with the vote. And Denisha, if you wanna, can we make an exception to the chat right now? Can you verbally say, or?
I'm fine. No? I'm fine being on camera.
Okay, great. All right. So the first option we're polling on is the newer OMC language with 1 revision, which is that it changed from required to present 2 cases per year to required to present 1. So Sammy, you got that change in the notes. Okay. So then hold up your hand for where you're at with that option, and then let me tally. Okay, just 1 second. Willa, I got you. Hermine, I got you. Jean, I got you. Nora, I got you. Denisha, I got you. Lennon, I got you. Okay, so and that's 7. Okay. For option 1 with the revisions that Nora made, hold up your hands for that. Okay, just 1 second. Willa, I got you. Hermine, I don't see your hand. Hermine, I got you. Nora, I got you. Lennon, I got you. Denisha, I got you. 1, 2, 3, 4, 5, 6. Jean?
Yeah, sorry,
Jean-
I'm confused as to why people are holding up different numbers. I apologize. I may not understand this system very
So
well.
5 is full agreement with that proposal.
Okay,
1 would be like full opposition to that proposal. 3 would be in the middle.
and is there an abstain?
Sure.
I'm gonna abstain from this one.
Okay.
Thank you.
Okay. And then option 2, which is the second option from the previous meeting. Hold up your hand for that. Okay. Willa, I got you. Hermine, I got you. Nora, I got you. Denisha, I got you. Lennon, I got you. And Jeannie.
Yeah, I'm feeling a little uncomfortable voting since I don't have the full information from the first meeting under my hat.
Okay.
So I feel like I should
Abstain.
abstain as well. Mhm.
Okay. Okay, so Sammy, let me tell you the tally for each one. Are you ready for that?
Hold on, Silka, are we including Jeannie's vote in the first one if she abstained from the second two? Or are we abstaining?
I think I should abstain as well, because as a first time member here, I was not aware I was going to vote, and I would
fine.
rather abstain. Yeah, apologies.
That's okay. And Jeannie, your one for the first one was a 5, right?
Yeah, because
Okay.
I didn't understand the numbers, and that's why when I clarified, so I think I should abstain. Yeah.
Okay. So Sammy, are you ready?
Yeah.
Okay, for the new OMC language, it was 3-5 votes, three full agreement, 1-4, 1-3.
Hold on. I gotta
Okay.
write this down and I can't write as fast as you can say it.
Sorry.
Okay, 3 people, full agreement.
1-4, 1-3, and 1-2. For the revised option 1, it was 2 5s, 1-4, 1-3, 1-2, and 1-1. And then for option 2, it was 1-2, and 5 1s.
And what's option 2?
It was the first option, the option 2 from the last rack, which we didn't revise. So it's the exact same language as the first time we did it.
Got it.
And I think that that's actually really instructive information to the board, like seeing that spread like that, seeing that there's areas of kind of mixed agreement and where there's a real spread. And I'm hopeful.
Okay.
That will be meaningful to them. So what's our next agenda item, Sammy?
The next agenda item, I gotta find my agenda. I got some stuff here. Hold on. Fiscal impact, racial equity statement, small business. I think we did that last time. I don't think that's changed. Well, I guess there could be less of an impact since you went from 1 to 2 on the OMC revised option.
Yeah.
So I could put that, I'll put that in.
Yeah.
And then next is we did the recommendation for the board. The rule timeline is, do I have the schedule in here? Yes. So, February the 9th, I thought it was the 13th. The board will meet and approve proposed rules. On March 1st, I'll file the notice with Secretary of State. On March 9th, the board meets. They're going to do nothing. March 16th, I'll have a hearing. The last day for public comment is March 28th. At the April 13th meeting, they'll adopt permanent rules, and then on May 1st, they'll become filed and effective. That
Awesome.
is the plan.
Awesome.
And then the next thing is public comment, and I believe we have Liz Bear on the phone.
Wait, can I ask one more thing?
Yeah, absolutely.
So, on our timeline of non-board stuff we talked about, our next joint meeting of the like midwifery organizations is coming up in February. And once we get a little further on internally, Willa, Lennon, and Nora, would you like to be like if we start drafting some kind of joint memo about confidentiality and peer review, would you like to be part of like a committee on that, since you've already been deep in these conversations? For me, I'm assuming I just was inherently thinking you were already part of it, but yeah. Okay. All right.
Okay, I'm going to read public members wishing to speak must first sign in on the roster. We already said that, never mind. At this time, the Board of Direct Entry Midwifery Rules Advisory Committee will hear public and interested parties' feedback. Members of the public, please wait until you've been recognized. Once recognized, please state your name and affiliation to the board for the record. What do I do? Oh, volume. Yeah. Liz?
Yeah, I'm here.
Okay. Okay, the committee's ready for you.
Okay, so I was taking notes while other people were talking, and I'm just going to read them because I feel like that's easier. So I agree that we don't want people practicing in isolation. However, I agree with the speaker who objected to peer review needing to happen through an entity or organization. I would support licensed midwives being allowed to schedule their own peer reviews independent of an organization. And I looked up the NARM peer review worksheet while people were talking. And I think NARM's requirement is that there needs to be 3 midwives present who are currently practicing, and it kind of stops there. And so that is what we use to renew our CPMs. So I would, propose that it fits the CPM model because licensed midwives in Oregon are mostly CPMs. It was interesting. So the next thing I wrote was, I agree with the presenter who said that having rules that are too specific makes it look like the board thinks that midwives are irresponsible and stupid. They didn't say stupid, that was the word that I used. But then it was interesting later when folks said it's important to make the distinction that the board is here to protect the public. So, if we're really being honest, the board doesn't have sides, but if they did, it's not midwives who they're investigating. On the other hand, I, don't think that it's a good idea to have to make rules that are too specific, because then we are implying that people can't figure this stuff out themselves because they're adults. So the next one is, I agree with Hermine that the distinction between mandatory reporter rules and confidentiality rules should be clearly defined. My understanding, and this is from when we were foster parents, is that from being a mandatory reporter can be held liable for not reporting abuse or neglect. And that, would apply in healthcare settings also. So if you don't make a report, then you can get in trouble for not reporting.
Liz, I think you cut out. I don't know if you stopped speaking, but we can't hear you any longer.
I muted my phone like a dummy, or my computer. Sorry. What did she said? She doesn't think there's a rule that would not allow the board to not review a peer review case that came in as an investigation. Is that right?
Yes. Oh, sorry. I'm still here. Yeah, I'm not familiar with an OAR that makes it clear that the board won't investigate complaints that originate from peer review.
Okay, is that everything? Oh, sorry.
Can I ask a question of Sammy and Heather? Yeah. In relation to some of the things Liz is bringing up, sometimes the board kind of issues, kind of like informational statements or letters. Like they'll be like, this is what this thing means. And I'm curious if this is an area where would be useful for the board to, or legal counsel for the board to say, you know, this is our understanding of the lay of the land in relation to confidentiality of peer review.
So this is Heather Vogelsong. I think Sammy is noting that as an interest that has been expressed both by quite a few people here, and then very specifically by you as well as an interest that she can take to the board. Usually they are addressed as like FAQs, questions and answers type things. I think that's what you're referring to. And those two statutes that do control this area are out there for the public as well, but providing more information on this and having the board decide that, Sammy can bring to the board at a future meeting.
Got it. What I'll probably do, what I imagine the board will want to do is once the rules become permanent, maybe do a FAQ about peer review and kind of, you know, pull out all the different pieces, and then this, we'll see if they want to address this, and me and Heather would work on something like that. Is there anything else? Liz, are you still there? Do you have anything else?
No, that was it. Thank you.
Just as a reminder, in case you didn't hear, the board will vote on proposed rules, which means they may make changes to them on February 9th, and then I'll file the proposed rules March 1st, and then from March 1st to the 28th, you can make comment based on the rules that the board approved. So in case some of the, you'll want to put it in writing, or you can come to the hearing and make that the same comments that you made today during that time frame. And they'll be noticed and out to everybody. Okay. The Board of Direct Entry Midwifery Rules Advisory Committee meeting is adjourned at 10:50 a.m. Good job, guys.